My name is Siti Sarah Aisyah binti Azhar. My metric number is 271777. What is contract law? Contract law is an agreement or a bargain made between two or more persons which creates obligations that are impossible at law. Contract refers to the agreement of the parties and the document, if there is one, which expresses the agreement. Some contracts not enforceable unless they are in writing and signed, for example, contract for the sales of land. There are 6 types of contract law. Firstly, formal contract, where it's signed, sealed, and delivered. Secondly, simple contract is an oral contract, written contract, partly oral and partly written that must have consideration. Third is the express contract, is one that said in words, either oral or written. Next, implied contract is one that is inferred from the acts and conduct of the parties. Last but not least, unilateral contract is the only one party, the promisor, is obligated to do anything. Lastly, bilateral contract are the two promisors and both are obligated a promise in exchange for a promise. As for the case, we have choose Rangkaian Hotel Sri Malaysia versus Husni Hussein. This case was happened between Hotel Sri Malaysia as defendant at Kuala Kedah and Husni Hussein as plaintiff on 2005, and the case was taken to the Alor High Court. The defendant and plaintiff make 2 agreements. The type of agreements used between Hotel Sri Malaysia versus Husni Hussein are simple contract, where one of the conditions to fulfill the terms of this agreement is consideration.
Assalamualaikum and good day for everyone. My name is Nur Atika binti Ibrahim, unit number 271636. Today we are going to present about contract law under Rangkaian Hotel Sri Malaysia Sdn Bhd versus Husni bin Hussein. This contract under consideration, we can say it on past consideration whether the contract was void due to the past consideration. Due to the civil procedure, this case was on mandatory injunction, whether there was special circumstance to warrant an injunction. Okay, now I'm going to talk about facts of the case. The plaintiff was the owner of franchise business in hotels under the name Sri Malaysia. Meanwhile, the defendant entered into 2 contracts, which is franchise agreement and premises management agreement, where the plaintiff become the franchise holder for Hotel Sri Malaysia at Kulim. The case started when the defendant were required to pay a franchise fee of 165,500 ringgit Malaysia to the plaintiff on the started date, as well as a marketing and promotion fund of 55,000 ringgit. Plaintiff issued defendant a letter on 28 February 2005 for advising him that he owns 221,969 and 42 cents in arrears with interest payable. The plaintiff reminding defendant if he did not pay, the plaintiff would terminate their services. Defendant accepted the amount but requests that it be paid in more than 80 payments. Plaintiff refused but was willing to accept 10 monthly payment instead. Defendant then applied to the High Court and submitted 18 post-date checks. Plaintiff disagreed one more and returned 8 of the checks, asking the defendant for the remaining funds. The defendant complied for the next few months but did not pay the existing arrears. On 20 July 2005, the plaintiff issued the defendant a letter to claim specifying the amount of the arrears as well as the statement of the account. The defendant recognized this but requests that the arrears be rearranged into 33 months installment. Plaintiff refused and sent termination notice starting 6 February 2006. And then defendant dispute the amount owed and state that plaintiff was not permitted to terminate and raise the issue on past consideration because the agreement was executed on 14 January 2004, but the start date was on 1 April 2004 and challenged the validity of the agreement, giving rise to the plaintiff failure to comply with agreement, including failure to take training and equipment and failure to promote. Plaintiff feel a required injunction rejected since there were no exceptional circumstance. I think that's all for the key facts of the case, and I will pass to the next presenter. Thank you.
There are two issues occurs in this case. Firstly, past consideration of franchise agreement and premises management agreements. Husni Hussein, the plaintiff, is the only owner of the franchise company at the hotel known as Seri Malaysia. On January 14, 2004, the defendant Hotel Seri Malaysia executes two agreements with the plaintiff, essentially making him the franchise of Hotel Seri Malaysia in Kulim Kedah. Defendant has failed meet his financial responsibilities under both agreements. The plaintiff filed a writ of summons and request an injunction against the defendant for continuing to manage and run the hotel through the summons in the room. Furthermore, the plaintiff filed for the numerous relevant orders to protect the plaintiff's right, and the defendant did all required to return to the hotel to the plaintiff. During surrender, plaintiff prayed for a declaration that plaintiff had to right to take over the hotel from defendant was withdrawn. Second issue are how strong and clear is the plaintiff case against the defendant. On this issue, it has resolved the law that the common principles of American Cinema Co. with Ethicon Ltd. or ER 504 do not apply to grant mandatory injunction in an interlocutory application. There must be a high degree of guarantee that if the matter is brought to trial, it appears that the injunction was properly granted. The plaintiff case is supported by contemporary documents in the form of correspondence between the plaintiff and the defendant, including the defendant's outstanding check relating to the payments due from the defendant to the plaintiff. From the plaintiff affidavit, the defendant went through no less than 4 letters dated 15 April 2005, 6 May 2005, 24 May 2005, and 5 October 2005, expressly acknowledged its indebtedness to plaintiff pursuant to both agreements. In the latter, none of the defendant dispute the various amount claimed by the plaintiff, nor was it ever stated in the letters that the plaintiff had failed to execute obligation under the both agreement. The defendant is not bound to respond by making the necessary payment.
My name is Nasala binti Abdi, matric number 271953. For my part, I will present about holding of the case, which means the judge's decision. In this case, the defendant's letter was explanatory rather than assigning blame to the plaintiff in response to the plaintiff's claims that they have failed to meet their commitments. Even the defendant's solicitor's letter, which for the first time denied the plaintiff's claim, made no mention of any breach of contract. The claim based on this ground appeared to be an afterthought. Besides that, the defendants in the reply questioning the plaintiff's applications and aroused some issues. First issue in this is the franchise agreement was held 14 January 2004, but the true date of commencement is 1 April 2004. This shows the defendant is giving the wrong date of agreement, which is 2.5 months later. Because of that, the defendants challenged the validity of the agreement. For the next part is rationale of holding, which means justification from judges. For the justification, the judges give the whole relief granted by intellectual order. In this issue for this case, the court is not obstructed from giving the intellectual injunction. In addition, even if the offers applicant his whole remedy before the trial, an injunction should be issued if there is clearly no defense to the case and the sole purpose in establishing a defense is to postpone the trial. The defendant had clearly breached the agreements. The circumstances indicate that an injunction would be granted against the defendants. The balance of convenience favors the plaintiff. Any delay would cause irreparable harm to the plaintiff, and the plaintiff had been helpful and accommodating to defendant by not terminating the agreement at the outset. For all of the reasons stated above, I am confident that the defendant has no legitimate defense to the plaintiff's claim. For the last part is conclusion, which is a contract in the hotel sector is an agreement or guarantee between two or more parties that the court will uphold. To put it another way, it is a system of rules that control the connection, substance, and legality of a contract between two or more people. The hospitality law was enacted to govern hotels, restaurants, taverns, country clubs, and other public facilities in order to offer legal safeguard for clients. At the end, in this case, which is Hotel Sri Malaysia, which is the defendant, versus Huni bin Hussein, the plaintiff, which the plaintiffs have been dismissed and the case has been accepted.